Hello, everybody. Welcome to the Public Interest Environmental Law Conference. Thank you for my panelists. Thank you to my panelists for this panel, Industry and Environmental Justice Issues. My name is Jack Delarusso, and I am a 1L PILC representative. I am moderating this panel. Before we begin, I just have a few announcements. The first is just a little tech warning. Don't worry if you can't see yourself. This is a Zoom webinar. All attendees are automatically muted with videos off, so you will only be able to see the panelists. Throughout the panel, if you have questions, please use the Q&A function rather than the chat function. All of our panelists will be giving their presentations, and then there will be a 15-minute Q&A session at the end where the panelists will answer your questions. Please remember to be courteous of all viewpoints throughout the presentation and Q&A session. Additionally, if there are any legal professionals in the audience wanting to earn CLE credit for this panel, the link to register and pay on the JOT form will be posted in the chat shortly. Also, our alumni board, Friends of Land, Air, Water, help to provide stipends for students doing unpaid public interest environmental law internships. If you are interested in making a donation to help provide students with these stipends, information to do so will be on a Google document, which we will drop the link to in the chat. Lastly, the University of Oregon is located on Kalapuya Alihi, the traditional indigenous homeland of the Kalapuya people. Following treaties between 1851 and 1855, Kalapuya people were dispossessed of their indigenous homeland by the United States government and forcibly removed to the Coast Reservation in Western Oregon. Today, descendants are citizens of the Confederated Tribes of Grand Ronde Community of Oregon and the Confederated Tribes of the Siletz Indians of Oregon, and continue to make important contributions in their communities at UO and across the land we now refer to as Oregon. PILC would like to acknowledge the traditional homelands of the Kalapuya people in the Willamette Valley and express our respect for the tribal nations of Oregon. I will now introduce our panelists. Mr. Alberto Saldamando is a lawyer advocate with the Indigenous Environmental Network, a position he has held for over 10 years. Mr. Saldamando specializes in climate change and global warming environmental justice issues and advocacy on environmental justice issues in the Native community. Mr. Gregory Sotir is an experienced grassroots organizer currently serving as one of the primary organizers of the Cully Air Action Team, focused on efforts to reduce industrial pollution and its resulting health effects in Portland's Cully neighborhood, one of the oldest and most diverse neighborhoods in Portland in which he resides. We will now start with an introductory question. And that question is, what can lawyers do to make sure they are more of a help than a hindrance when helping communities address environmental justice issues?
Well, I guess I can start off with that. Good morning, everyone. My name is Alberto Saldamando. I'm a Chicano Zapoteca. I live in San Francisco and what is now known as San Francisco and Moekmi Ohlone land. I think that indigenous peoples, I think it's really necessary for lawyers to follow the protocols of those people. I remember, oh, by the way, I've been doing international work since about 1990. I previously worked with the International Indian Treaty Council, doing international work around human rights and the rights of indigenous people since that time, actually. And I started working with IEN about 1993. Even though I was staff of the Treaty Council, we did IEN work as a sister organization. But anyway, I think what's really important with indigenous peoples is that protocols be followed, the local protocols of the people that you're going to be representing. Certainly individuals can be represented without any kind of, with direct consultation with the client. But when you're representing a community or a nation, those communities and nations have protocols. And it's really necessary to follow those protocols. For example, I remember I did while working with Treaty Council, we were doing a treaty study with the United Nations at that time, the Working Group on Indigenous Populations. And I represented the rapporteur that was writing the report to the Kunas in Panama. And I was told, really, they have what they call an AGAR, which is a person that deals with people from the outside. And so the process was explained to me. We met with the whole community really, and the elders in their hammocks, as is their custom. And he explained to them, he translated for me into Kuna and explained to them who I was and what I was doing there. And I really was just quiet because he had already interviewed me. And that's when then the community asked me to leave and they discussed it. And then I was invited back and told, okay, you can do what you're going to be doing. You can interview people at will. And if I hadn't done that, if I had just shown up, walked into the community and started talking to people, it would have really been somewhat of a, I don't know, it would be very insulting, I think, or at least unacceptable for us to approach them that way. I was very lucky that the AGAR, they had a system already set up so that the AGAR could explain to me what would happen. Met with the elders, or actually they're elected. They're self-appointed, self-perpetuating elders. And I got to be actually close to a couple of them. One was an elder who knew a great deal about traditional medicine, traditional plants. He died very recently. But anyway, that was the process that we followed there. It was about it was in the early 90s where we did that. More recently, we went through the same I went through the same kind of thing at Standing Rock. When I was at Standing Rock at protesting the DAPL. And I was not really there to do much. I mean, I was there to participate, but not, well, I did participate actually in the legal tent and in other places, but I was invited to talk to the elders, to the traditional elders, the Standing Rock Council of the Seven Fires. And they invited me into they have a tent, a large tent with 7 teepees consolidated. And they invited me into the tent and they asked me who I was and to explain myself. And I did. And then they asked me about my credentials. They asked me who I was, where I was from, if I was indigenous, all that. That was their protocol. And then once that was over, they asked me to write an intervention for them at the UN. And so I sat there and they told me what they wanted addressed. So it's really important to know at least that that these national, international, what I would call peoples, not individuals, but when you're representing a group, a nation, a tribe, that you really get to know what their protocols are and follow their protocols. And if they want consultation, they'll tell you. If they don't, they won't. They'll tell you to go away. And I think it's really important to do that. There's certainly I haven't really been around where those things have been violated, but I do know that there are lawyers that will go to a community and say, we want to represent you, we're going to do this for you, we're going to do that for you, and expect to get paid. And sometimes it doesn't work out. It doesn't work out that way. It's also, I think, I don't know, I could stop there and let Greg take a shot. I've got a couple of more things on collaboration that I thought might be useful in this discussion. So it's
yeah, I think, I mean, I don't want to repeat everything that you just said, but I think you said it pretty eloquently. I mean, you know, from a grassroots perspective, we generally rely on lawyers to do, you know, policy work, filing legal suits and things like that. And I've noticed over the past like 20 or 30 years that, well, at least in the environmental movement that I've been involved in, the direct action movement, that lawyers have become more more advocates, and that's a really great thing. However, it does seem like, power dynamics are still in place, and so when lawyers sometimes come into a group where there's already a strong network in place, where the webs have already been developed and built between relationships, and where people have had each other's backs in difficult situations, and a lawyer arrives, it's kind of like sometimes it creates this well, it's not really an inequitable system, but it's a power dynamic that needs to be, I think, reviewed and perhaps even rehabilitated to a certain point, to develop an idea of shared trust, between the people who are actually on the streets or on the front lines, and the lawyers who are there to assist, at times even to advise perhaps, but really to assist. I think as these different groups, legal teams and more direct action advocates or grassroots activists can work together, then there should be a merging of identification of priorities, so that both sides of that group become closer together as an organic whole. And I see that this is something that's happening, and I'm really happy it's happening. It seems like it's happening in a sympathetic manner, and one that's generally rather respectful. Although, as Alberto mentioned, I know that there are people out there who seem like they're either unaware or might have other agendas in terms of lawyers getting paid for their work and so on. I think that the issue of accomplishing a task, though, is the main priority. So lawyers, I think, when you're going into these struggles, it's important for you to recognize all the dynamics, to become part of the dynamics, to show your advocacy in an authentic manner, to listen, as Alberto said, and then to merge, if you can, with the movement itself. If that helps out in that sense, I know also that there's times when pro bono work is involved, or where contracts have to be, codified and so on. And those are confusing to a lot of people, especially at the contract level. So like sometimes if you go in to represent a group of individuals, it's good also to reflect there on the power, like who are you representing for what, and what is the reason why the representation in that contractual method needs to be there. Because quite frankly, I think for a lot of grassroots activists, especially ones who aren't well versed in the dynamics of the legal system that we have, which is kind of choleric at times and certainly Byzantine. Contracts are frightening. They're just frightening things, and it's important to be aware of that. I think also that sometimes there's a push by lawyers to create what are called good neighbor agreements with polluters, and that those have to be very, very careful. In my mind, it's almost like a plea bargain, because it doesn't really, I think good neighbor agreements can be very, very problematic, especially when future litigation is prohibited on the part of the community. And I'll leave it at that. If Alberto, you want to continue into the directions that you were talking about earlier.
Sure. Just to follow up on what you said, tribal governments in the United States and Canada are very accustomed to dealing with private attorneys. And they do have private attorneys on retainer. And sometimes those attorneys will not take a case because they for one reason or another, like in Standing Rock, we wanted to raise the issue of treaties. We
Right.
wanted to raise the issue of unceded lands,
Mhm.
and they just weren't interested. So, but the attorneys we ultimately ended up with did agree that although the environmental impact statement was really the crux, the kernel of that lawsuit, that they would include the treaties as another cause of action, which is really, I think, a more collaborative way of working with people. I think you have to be aware that these private attorneys are accustomed to getting paid a lot of money.
Yeah.
And I mean, for one, I think the memo where they turned us down was they charged the tribe $1,500 for a half a page. I think really that's kind of untoward.
Well, that's the corporate model, right?
Yeah,
I mean,
yeah,
that's
that is a corporate model.
and it's important to realize that when you're dealing with communities, the corporate model can only go so far.
Yeah,
In fact, it can be counterproductive, I think,
it
to
is.
build
It is.
alliances.
No, it is. It is counterproductive. I think when you're trying to collaborate with a community in terms of a lawsuit, you have to take and respect the views of the leadership. And I think there is critical to understand that there are businessmen on tribal councils. There are men on tribal councils that look at it from a perspective of making money for the tribe and for themselves, really, in many cases.
Yeah.
But not really representing the interests of the traditional people in the community. I've come across that like in, well, so who you're representing is really important. Are you representing you have to really figure out if you're representing the traditional people or you're representing the tribal council. In Standing Rock, it was both. There were traditional people on the tribal council. The chairman was very much involved in DAPL, and so there was that unity, that unity of spirit and thought with the tribal council. But there are some tribal councils that don't. I think there's like a tribal council in the affiliated tribes of North Dakota. They're frack. They're selling fracked oil, and as a matter of fact, the fracked oil is going to go through DAPL. So
Yeah, tribal councils can be really problematic. I know from personal experience as an educator who's worked in Native American communities. And again, that I think undercuts the whole issue. Are you going to go towards the established hierarchy, or are you going to try to figure out how is the litigant, or how is the people who are marginalized being affected negatively by the polluter industry, and figure out the best way to address their needs. Personally, I'd say go with the latter. I mean, hierarchies do exist for a reason, but sometimes they can become like they can exist for too long and establish their own methodologies and so on.
No, they've got a big problem in the affiliated tribes. Just as with the extraction going on, they set up these man camps, which are these young men that have nothing else to do but work at the camp, and so a lot of the young women end up being raped and murdered,
Trafficked.
and trafficked. So it's really the traditional people understand that, and they don't like that. And I think that there is no conflict really. I think unless the tribal council can't tell the traditional people they can't be represented. So you can, in fact, do a lawsuit with traditional people without regard to the tribal council. They can't enjoin you from representing who you're representing. There's another aspect of it too, I think, but that is a big problem, I think, throughout Canada and the United States. In other countries, traditional people are, in fact, the leadership of their communities. And so it's possible to form relationships with them, following their protocols and listening to what they want, to be able to do international litigation, I think, and that would be with the commission, the Inter-American Commission. It could be with some of the international mechanisms for human rights. ILO 169 has a complaint procedure that can be very effective, actually. So it is possible to represent traditional peoples without regard to the businessmen in the community. I mean, some of those guys are really weird. So anyway, the other aspect of it is that when you're approached by if you're approached or somehow come across a community that wants to protect the sacred site, a sacred area, it's important to know that other tribes have similar interests. Like Big Mountain, Arizona, I think there's 9 tribes that consider Big Mountain sacred. And so it's important to take their views into consideration. I think when I was doing a case before the Committee on the Elimination of All Forms of Racial Discrimination, I met with them. There's an intertribal organization. And then I met with representatives of the 9 tribes. And we talked about what they wanted. We talked about what the litigation would entail. And they gave me the go ahead, and they appointed a guy to be in the contact with me. So it's really important to know that there may be other tribes that have an interest. I think particularly in extraction as well. Some tribes who live away from the site might like the jobs, might like the whatever is happening, but your community doesn't want it. And so there may be conflicts, but those conflicts, I think, are best handled by the tribe itself. I think like the Longhouse and the Napi Longhouse, if there's a conflict between tribes, not between individuals, but between tribes, and actually maybe sometimes individuals who are upsetting the balance in the community, the elders in the Longhouse can discuss it and they can come to a resolution about it. I know there was a case that was brought by another indigenous legal organization in Belize, I think. I think it was Belize, where they did not. They only consulted with one tribe, with a particular Mayan entity, but didn't consult with other Mayan entities when they went to the Belize Supreme Court to have the Supreme Court adopt the Declaration on the Rights of Indigenous Peoples as law in that country, which they ultimately did. But there was a lot of conflict because there was no consultation with the other people, because he was purporting to represent the Mayan people of Belize. And the other tribes, the other say, I would call them tribes or clans within that tribe, felt there was some hostility. And so it took elders from all those people to get together to resolve the dispute in a peaceful way where the lawyer was not invited. So I think it's important to know that what other interests, or at least find out what other interests, what other people are really have an interest, whether it's an emotional interest or a relationship interest or a physical interest in the land. Sometimes there's litigation can ensue where means of subsistence is somehow involved. And people have to understand that this will not affect their means of subsistence, because if it does, then I think you're in a bad place. I think you can't really put people's subsistence at risk, even if the lawsuit is winnable. So I think it's important to know all those things, to know about the relationships, who you're consulting with, how you consult with them, and ask them and others if there are other communities that have a particular interest in that litigation.
One of the issues that, I've come up with in terms of dealing with industrial polluters, and I think in EJ communities in general, we can extend this to a certain extent, is that, it's really hard sometimes to think in terms of legal compromises.
That's another one, yeah.
We see the problems as they exist. We can smell the toxicity of the air. We can see the the cancer rates and the asthma rates in young people. And, we can see the clouds of pollution that hang over certain industrial facilities. And the problem is quite obvious. And so when we start to organize, when grassroots organizations and individuals start to organize against those polluters, they're looking for, a kind of a solution that really is effective and a solution that stops the problem and protects the health of the individuals in the community. But given the justice system as it exists, sometimes that's impossible. And that's one of the things that we've run into here in Portland, Oregon. We've revitalized our state agency, the Oregon DEQ, to the point where they actually can be more effective than they ever have in the past. Yet still, the process is pushing them towards trying to get grassroots organizers to compromise with the industry, to say, well, we can go so far, but we cannot fix the problem entirely. We can ask the facility to do this. We can hope the facility doesn't lie when they're doing their self-monitoring and their self-reporting, even though they have in the past. And so it's really confusing at the grassroots level. One of the things that I think that legal advocates and lawyers can do is they can really work to be persistent with these agencies, first of all, but also to be innovative in strategies. And it's, Alberto, when you were talking about, some of the issues facing Indigenous communities and talking about treaties and so on, I think sometimes lawyers have a tendency also to kind of fall into this, like, well, okay, the agency says we can only go so far, so yeah, that is only as far as I can go. But that's not really true. That's not really true. I think some of the court cases moving through the system now that are dealing with fundamental principles of individual identity, of constitutional protections, from the climate change perspective in particular, can be really, really instructive of how we want to move forward with lawyers, in advocacy on these issues. We have to be innovative and we have to be smart, and we have not to settle. If we have to actually go back and change the inner mechanisms of how agencies function at the state level, that's what we need to do. And that's kind of what we did in Oregon with Cleaner Air Oregon. Other states have different setups. Unfortunately, here in the United States, we don't have really an overall plan. In fact, it seems like the EPA might be disappearing after this, SCOTUS ruling coming up. But, at the individual state level, advocates need to get those policies in place that make their agencies effective. And then the legal system has to push it. Because here on the grassroots level, we're persistent and we're not giving up. But it's daunting. Corporate lawyers, big money industries. I mean, the lawyer that we've been dealing with this one particular polluter, he seems actually, like a very, very nice person. And I know he's getting paid a lot of money, but geez, he doesn't really seem terribly smart to me. He's willing to jump through the hoops that the corporations have set up for him. And I suppose he does so effectively, or else they would, just get one of their other lawyers onto it. But I'm always amazed at how lawyers who are advocates, they generally are very, very, very smart, and they are very dedicated. And if they start to build community with those grassroots organizations that you're working with, I think some really good things can happen as a result of that.
No, it's true. I think IEN, for example, is really a network of communities in resistance to extraction. That's the way we started. So we try to provide support, direct action training, whatever, within our disposal to be able to help them do that. But to really go back to your point about settlements, there was a litigation around the the nuclear development in Hopi, Navajo, where they had this uranium mine and they were spilling their yellow jack,
The tail.
whatever, tailings all over the place, and it got to be a real problem until the EPA finally figured out that it was bad, you know. And so the litigation ensued where the lawyer came up with a solution saying, you have to move. That was the settlement.
Mhm.
But people don't move, you know. I mean, it's not that the people are not really accustomed to moving. I mean, and their hogans are built around their umbilical cords. That's where they were born. They came from the earth from that place, and they're not going to move. Although some people in the tribe, the younger people, did move because the housing would be paid for, and it turned out it was going to be built around in a very polluted place anyway.
And it breaks community, and it breaks the
It-
community structure.
Well,
It
but
breaks that circle of life that is just so important,
that's right.
marginalized, and especially to Native communities.
Yeah. So what happened was we were working with the sovereign Diné elders, which is a group of Diné elders that were just not going to move. I mean, they could come with helicopters and guns, but they were not going to move. So they agreed. The company agreed that they could stay in their hogans. The tribal council agreed that the elders and really anybody that wanted to could stay in their hogans and just live out their lives where they were and not have to move. And the sovereign Diné elders did discuss it and did accept it. We represented them before a UN mechanism, and actually the rapporteur came and interviewed them and did write somewhat of a half-hearted. I mean, he focused on haircutting in prisons and not really on the problem that we had presented to him with regard to the industrial pollution. But they did agree after they discussed it, and after they discussed it with others, and they discussed it with ourselves, and they did agree that they would stay. And so what happened was they did stay, and I think there's still some surviving members, although they're very old and somewhat infirm, some surviving elders that are still living in their land in their hogans. There's another issue I came across once with Cancer Alley in Louisiana, where the solution was that people had to move, but what people wanted them was to go away. They
Right.
want the polluter to go away. They don't want to move. They don't want to leave their land. They don't want to break up their community. They just want the polluter to leave. And that's true in Richmond as well. And I don't think that lawyers are willing to take that on. It's too much of a hassle. It's too much of a battle. I mean, they would probably get kicked out of court on demur, even just at the filing. But the fact is that that's what the community wants.
And one of the deeper problems there also is that the polluting industry, whether it's Peabody Coal or United Atomic or whoever it is, or the plastics companies in Cancer Alley or ExxonMobil, they just pay a small relocation fee for 50 or 60 families, and it's just like, business as usual.
Yeah.
We're going to continue to pollute. We're going to continue to desecrate the land, and we're going to continue to create cancer clusters, for anybody who wanders into this land. Cleanup, remediation costs, punishment. I mean, the legal system, as far as I'm concerned, is supposed to be a relief for people's injuries.
That's right.
But it's also a dispenser of punishment as well. And if these corporations are never punished, except in a minor monetary way, then, the problem just repeats itself over and over and over again.
And it's really inherent in the legal system, as you say. I think the EPA is supposed to protect people.
Yeah.
With regard to this nuclear pollution and yellow cake, the Acoma Pueblo was very much a part of that. And they still have to buy bottled water because the water table is radioactive.
Yeah.
And the EPA came and it's a Superfund site, so it was their responsibility to clean it up. But instead of cleaning it up, they just bulldozed dirt over the yellow cake.
Right.
But then the wind comes and blows the dirt away, and people are it's radioactive again. It's the law does not offer the solution that people need.
No, it doesn't. I mean, we have that problem here with PCBs, and
Yeah.
this one industrial polluter in particular that I've been working on with for the last 5 years, a major glass recycler called Owens Barkway. They basically dumped PCBs into this adjacent lake that was very, very close to Chinook villages, that are long gone, in this really beautiful area called the Columbia Slough. And it's just been, the area has been devastated by industrial, polluters for the last century and a half or so. But in particular, all they did is they put a clay and silt, cover over the PCBs in Johnson Lake. And as far as the state is concerned, well, the problem is solved. But the PCBs, as take the benzene ring lasts a long, long, long time in the environment. And sooner or later, there's going to be some kind of disruption of that clay layer, and the PCBs will be back into the bioaccumulative, environment, like they had never left.
That's right. Actually, there's some questions in the chat that might be interesting in the time we have left.
So we're entering the Q&A session now, but before we begin, I actually had a question of my own to ask you guys. So we talked a lot at the beginning about building coalition and communities when dealing with environmental justice issues, and specifically, as Alberto had mentioned, working with multiple different tribes on issues that are specific to not just the group that we're directly working with, but also groups surrounding who have a stake in the results of whatever lawsuit or agreement we come to. I guess my question was, when we're working as like the primary legal advocate for a particular issue, and there are disputes or resolutions that need to be come to through or by the different groups, what's the best way to work inside of that framework in order to be more of a help in terms of building that coalition to address the issue rather than getting in the way? Because as being the primary legal experts, you probably might think that you know more about the law or what's going on than the other people do. But you also want to make sure that you are carrying, or that you are keeping best interests of the groups that you're representing at the heart of what you're doing. I was just wondering if you guys had any personal experience on that, or maybe the best way to address a conflict resolution in that framework.
I really think that talking to people is the best way to resolve things. I think that getting the leadership of the communities or the people involved together to try to resolve the issue is a good way to go. Sometimes it becomes a tea session where people have to vent, and I came across that situation in Northern California once, where a lady's father was accused of being a sellout, and she had that in her mind. And she wanted people to apologize and was very angry about it, but that was what the rumor that had developed in the community. But we all got into a room and we let her vent, and we responded, and the community responded, and then people did apologize, and they said, no, we didn't know about all these things, and thank you for telling us. And then we were able to proceed. But so I think that getting, like I was saying with regard to indigenous peoples, getting their leadership together, their elders together, and having them work it out. If they can work it out, and you can talk about your loss with them and what you hope to accomplish, and they agree generally, and it's normally by consensus, so it may be a while, it may take time, but it's worthwhile trying at least. If in fact they come to blows, and it just blows up on people, then I think you're better off not dealing with it.
And I think in marginalized communities, two good techniques are the community meeting that can be set up, and legal people can attend that meeting as participants, and then maybe at the next meeting be more assertive about who they are. And another way is basically going door to door in marginalized communities, and just talking with people one-on-one, as Alberto said. It's getting past this basic power dynamic that I was talking about in the beginning, because I think in many communities, lawyers are looked at in a particular way. They're looked at as somebody who's either going to get them out of jail, or they're going to
Put them in jail.
put them in jail and charge them money at the same time. So there's like, I'm not saying that, the lawyer advocates that I'm talking about and that are at this conference are like that at all, but it's just it's a perception that can be addressed through community meetings. And I think it can also be addressed, by doing like a door-to-door kind of thing, and seeking information about how the problem is affecting people. People are very, very, at times reticent to attend a meeting also and say, yeah, my kid has nosebleeds every day, and he has nightmares at night, and he's scared to go outside and play because, there's too much violence. But if you actually meet that person at their doorstep, they're usually more than willing to tell you about negative health effects, in particular, that come from industrial polluters, and also of the environment that has created, which is usually a rather toxic one and quite often violent.
So would you describe that as a more personal connection approach then, rather than just as like so you're becoming personally invested in the community?
I would, yes.
Yeah, to a certain degree, yeah, but still, it's the community that has to deal with it. And if they deal with it in a good way, then yeah, you can become involved. But if they can't deal with it in a good way, then don't do it.
Thank you guys for your input. We can get started on those questions from the chat now. Yeah, the first one being, given our justice system as it is, how often does real justice prevail, and how often do we get the best legal judgment money can buy?
Money can buy is troublesome.
So is real justice.
No, I mean, there are laws against murder too, there's laws against pollution, there's laws against poisoning people. I mean, the best we can do is charge them as a public nuisance,
Right.
when they've been really killing people. I mean, the way I look at it, like these are all basic human rights. And the reason we have to have human rights is because they're not observed. If you live in a nice house and you have a nice income, then you don't worry about the right to housing and the right to a wage worthy of dignity. But if you don't have those things, I mean, I talked to a guy once from the State Department who said that there's a human right of leisure in the Declaration of the Right on the UN Declaration on Human Rights. And I said, yeah, maybe for a law professor, leisure can be ignored. But if you're a 10-year-old working in a sweatshop, then it might be very much appreciated. So it really depends on where you are. But the demand for human rights is universal, and it continues precisely because it's not been achieved.
One of the problems that I found, with that is that, when you're trying to address policy issues, if somebody is poisoning somebody, or somebody gets murdered or shot, you call the police, and the police arrive, they do a cursory investigation, they may or may not arrest, and the prosecutor will file charges, yada, yada, yada. But with corporate polluters, none of that happens. None of that happens. So one of the techniques that I found to be useful is in policy setting is to try and convince boards that, the crimes of industrial pollution are actually crimes of violence, that there are real, effects, and those effects end in people getting harmed or dying, or, and of course, then it devolves into risk analysis and all that. So there's all these legal mechanisms that are put in place to obstruct, to stop moving forward in that direction, to hold things accountable. But I think you really have to, toe that line that, industrial polluters are committing acts of violence.
Yeah. And the struggle continues. Yeah.
Yeah, and the struggle continues always. Yeah.
Excellent.
Persistence.
This next question, I believe, as a precursor, is probably referring to the recent lawsuits regarding the opioid epidemic in America. But the question was, what would be required for liabilities to be established for pollution in the same way that big pharma drugs have been established and enforced?
Not in this country.
Yeah.
I mean, that's why we have the EPA, right? The EPA is the buffer, zone between that. And, depending on the administration, the EPA can be effective or they can be a hindrance,
Yeah. No, and actually it wasn't the EPA that brought the pharma lawsuit. I think it was the Food and Drug Administration.
Right. Well, the FDA was forced to bring that because of activist lawyers who took on big pharma and were having community meetings in West Virginia, who were going door to door and, affected communities and saying, it was that hands-on kind of approach. And it forced the FDA into action because the FDA was corrupted by the process. The EPA, I think, is the same thing, but it's a buffer, right? It's a buffer. It's meant to like, oh, you don't have to take these people to court because we can solve the problems for you via compromise.
Or worse, you have the Chevron decision that says that you take the side of the regulator.
Right.
If the regulator says it's all right, then it's all right. That's Scalia for you,
Well, sometimes I wonder if ExxonMobil is really our government,
They are.
Yeah.
They've got 300 lobbyists.
I know.
Oil companies have 300 lobbyists, and in fact, in Washington, in fact, there were more lobbyists, oil company lobbyists at the last conference of parties of the climate change convention than there were indigenous peoples or civil society representatives, really. So they're there. They do right now. They're in good shape.
Another difference with the opioid settlement, it's not really big pharma, but there was one clear target there, right? With industrial pollution, there's
That's
not.
right.
So it's
That's right.
like getting
That's
a
true.
class action suit. I mean, who do you target? Kier McGee, Peabody, Exxon? Who do you target? I mean, or do you target somebody like Owens Brockway, which is a company you probably have never heard of, but they're the largest national grass recyclers. And in some states they use filters and in some states they don't, because they know the system is set up, it's gamed where they can get away with this.
We do have a campaign in IEN called Keep It in the Ground. And with working with the Rainforest Action Network, we're identifying not the oil companies, but the banks and financial institutions that support them, that lend them money,
Right.
that invest in their infrastructure, in their extraction. And we have a divestment campaign and shutting off their water. We want people to move their money away from these banks that aid and abet the oil companies. And hopefully that will be the pressure to keep them from at least more development. And it's to a degree, it's been working. So it's if you can't get at them directly, then maybe you can get at the people who allow to who aid and abet them. Insurance companies is another target that we hope to develop. Who insures those developments? These companies are risk averse. The banks are risk averse. They're not going to invest in something that is risky.
And last, oops, I'm sorry.
Go ahead.
And one more thing, you can challenge state agencies to implement the regulatory laws that are already in place. And if they don't, threaten them with a legal suit.
Yeah.
Threaten them with dereliction of duty or whatever it is that you legal eagle minds come up with. But that's one thing that can be effective, because bureaucrats don't like to be sued, and governors don't like to deal with like a whole bunch of lawyers telling them they're poisoning people.
Let's get through these last two questions while we have 4 minutes, but those were some really interesting responses, and I appreciate both of you. This next question just asks for comments on a statement, but the statement is this: one useful strategy for tribal governments is to form alliances with environmentally aware industries who are themselves being injured by big polluters. I work for the West Coast commercial fishing industry, for instance, which works closely with several tribes to clean up polluted salmon-producing watersheds, remove salmon-killing dams, and many other salmon protection issues in common as all people of the salmon. There are good industries and bad. Allied major economic interests help. Do we have comments?
Yeah, no, that's true. In fact, in DAPL, we had Dallas Goldtooth, one of our organizers, formed an alliance with local ranchers who didn't want the pipeline either. They called it the Cowboys and Indians. There are good industries. I mean, if he knows of good, we're not suing the good industries. We're going after the bad industries.
I think of Judy Barry when that comes up. I mean, and how she built, strong connections between, workers at small, individually owned, timber companies, which dot our landscape here in the Pacific Northwest, versus, the large, corporate, timber Georgia Pacifics that come in and just take everything over and do as much damage as they can and hope they don't get caught. So building alliances is, extremely important. And I think most people, in terms of the environment, even though it doesn't appear in those ABC polls, I think people generally believe the environment should be clean. It should not be toxic. It should not, everything should not be cut, or, the land should not be, raped so that you can get to the gold and uranium and whatever is underneath there and just leave it, or lithium, right? It's all lithium now. So alliances are important.
Yes.
Last question. I'm not sure if either of you have an experience of this, but we could talk generally about the situation. If not, the question is, would either of you like to comment on getting conflicted out of a case because of differing settlement provisions of joint plaintiffs? Also, have either of you seen or used lead plaintiffs' agreements to avoid this ethical problem of conflicting joint plaintiffs?
I'm not a lawyer, so I have no idea.
No, I mean, just the way it's described, it's a difficult situation. I don't know. I don't know what one would do. That's a tough one. That's a tough one. But yeah, you get conflicted out. That's good. I mean, you're off the hook.
Well,
or you can sever the case and have the conflicting parties represented by their own counsel. I think that's one way to approach it, and I think the court should go along with that.
All right. Well, we're on this last minute here, and we should probably say goodbye because there's the next a panel starting immediately after. So I'd like to thank both of you so much for taking part in this panel. I'd like to thank all the attendees for sitting in and listening to this conversation that we put together. It's been very enlightening and very amazing for us here at PILC to have two experts in the field. And just final reminders, if anybody needs those links to the CLE credit or the FLA stipend donations, that is linked in the chat. And we do have other panels coming up throughout the rest of the day, so please consider attending. Thank you again, everybody, so much. Take care of yourselves. Have a great Sunday.
Thank you. Bye.
Don't give up the fight.
No, never.
The earth needs your advocacy.